First, I'd just like to introduce some of ACT's fantastic MPs and candidates this election. Karen Chua, Minister for Children, needs no introduction, standing for us in North Shore. Very proud to have her on our team as always. Paramjit Parmar, another incumbent ACT MP, standing for us in the seat of Pakuranga, and Henrietta DeVoe, our candidate for Otahuhu, and is a very, very impressive person that we are eager to get into Parliament. We're here today to announce a policy which we call One Law for All and One Future Together. It responds to a concern that many New Zealanders have that it feels like democracy and the rule of law have become shaky in New Zealand. Parliament makes a law, and then the courts take it upon themselves to make a different law in its place. You can think about the Marine and Coastal Area Act, you can think about 3 strikes. In the first case, Parliament had to actually restate what it meant because it seemed that the courts had deliberately misinterpreted the Marine and Coastal Area Act. Then there was the case of 3 strikes, where on multiple occasions the courts decided that Parliament didn't really mean what it said, and they took it upon themselves to side with the guilty rather than the victims of violent and sexual offences. These changes to the Constitution Act, the Bill of Rights, the Legislation Acts and the Senior Courts Act are a coordinated set of policies to put the people, the Parliament and the rule of law back front and centre, so people can have certainty what the law means, will not have their property rights eroded, and will be treated equally with one law for all and one future together. First and foremost, the ACT Party will be campaigning to add to the Constitution Act the idea that Parliament is sovereign. There are many good reasons why Parliament should be seen as the highest lawmaking body in the country, and the prime reason for that is that Parliament actually has to go and seek a mandate from the people every 3 years, as we are doing now. The courts don't hold elections, and they do not have the legitimacy to start making wide variations in the law as put forth by the Parliament on behalf of the people. That is why we also seek to add to the Constitution Act the idea that the rule of law is fundamental. It is not good enough to have a court system where laws that have been set down over a long period of time can be changed because the courts see a different version of New Zealand's future from what was actually elected. And finally, the idea that all New Zealanders are equal before the law. These directions to the courts will allow citizens to challenge laws and practices that do not accord with the fundamental rights of New Zealanders to own property, to be equal, and for their Parliament that they elect to be sovereign. We'll insert property into the Bill of Rights because New Zealand is among the only countries in the developed world that does not have property rights in its statute books. Extraordinary that our right to protect property and not have it taken away, whether it's a significant natural area put on your property by a local council, whether it's your greyhounds taken away or your firearms confiscated by a government without compensation, that is something that would not stand in Canada, in Australia or the United States. Every other developed country has property rights in its core statutes to reflect that the right to own property and the need to voluntarily exchange it with other human beings is core to being human. You don't just take stuff because it's popular or because you would like to. We would amend the Senior Courts Act and the Legislation Act to make clear to the courts that we do not believe it is up for them to legislate from the bench. We would make it clear that Parliament is the one that must be listened to when the law is interpreted in the context at the time that the law was made, not with the courts deciding that they can take into account their own reckons and change the meaning of a law later on. In particular, we would make clear that tikanga should have its conventional and traditional meaning. Tikanga is part of New Zealand. For some New Zealanders, mainly Māori, for example, in a dispute between 2 iwi, tikanga can certainly be relevant. But tikanga was completely irrelevant in the case of the Peter Ellis appeal, where after his death, tikanga was applied to a person who was not Māori, had no use of tikanga in his life, and had no other people in his life or in the case where tikanga was applicable. That extension of the traditional role of tikanga to any other type of law was judicial activism of the highest order, and it creates enormous uncertainty for New Zealanders who want to work, save, invest and grow this country when the courts can just change the meaning of law. And finally, we would have vague treaty clauses made properly through Parliament's and Cabinet's processes. At present, the statute books are littered with vague references to honouring the treaty and giving effect to the treaty and having reference to the treaty. All of these different legal constructs have been lazily added to the statute books over the last 20 years, leaving a wide array of interpretations open to the courts. And this is not all about blaming the courts. There's certainly been some judicial activism, but it is also Parliament's fault that our institution has been unclear what it means by its laws at various times, as was noted by the Attorney-General in his recent, and I must say very good speech, to the Auckland Law Society. These four changes to the Constitution Act and the Bill of Rights, to the Legislation Act and the Senior Courts Act, and finally to the Cabinet Manual so that treaty clauses are made properly, are designed to restore confidence and certainty that New Zealanders know what the law is, can predict how it will be interpreted by the courts, and can get on with unlocking New Zealand's potential. People are sick and tired of legal uncertainty. They're sick of judicial activism and politics at the courtroom. What they want is a first-class Western world law system that actually works for all New Zealanders, so we can start going forward with one law for all and one future together. I thank you for being here today. I'm happy to take questions about this and then any other topics that may have emerged during this glorious day in politics.
You say judges have become activists. What examples do you have of that?
Well, I've just given several examples. The idea of extending the remit of tikanga all of a sudden, for no reason, in a case where it was completely irrelevant, that was an attempt to change the law in New Zealand according to a political fashion, rather than continue the long history of precedents being built on precedents as and where relevant to the case. I take the Marine and Coastal Area Act. Parliament had a very clear intent. We then had to legislate again. We shouldn't have to say it twice to the courts. They distorted that by, again, using tikanga to extend what was continuous and undisrupted occupation or use to, well, maybe if you were there some of the time and shared it with a few other people, that's okay. You take 3 strikes. We very clearly said 3 sexual or violent offences, you're going down for the max. And then, of course, the courts decided that it was up to them not to enforce that law of Parliament. This is unacceptable. People are looking at an election right now believing that the people they elect will be making the law, not people that, with all due respect to some of our jurists, they haven't actually heard of and certainly can't elect in or out.
The Treaty Principles Bill was widely opposed. It was ultimately voted down. It didn't even get support from your coalition partners. So what makes this package different?
Well, first of all, the Treaty Principles Bill was widely supported when you ask New Zealanders about the principles in it. We may have lost the vote because of our coalition partners. We still won the argument. You'll note that a lot of the resistance to the Treaty Principles Bill was about the treaty itself. This puts in place equality before the law, but it does not talk about the treaty, except that treaty references should actually be clear.
Are you happy to be risking another hikoi, another sort of round of 3 years of sort of strained relations between Māori and Pākehā?
The truth is always worth a risk. The simple truth is that societies don't work when the law is uncertain and when people who aren't elected change the rules of the game with no obvious reason or warning. There may be people who oppose this, but frankly, if we're going to say that we won't stand up for the truth because other people are going to try and veto it by marching, I don't think that we're taking this country seriously.
Is this a bottom line in any coalition talks?
We haven't announced bottom lines and we don't intend to do so. We've found that the ACT Party can get an enormous amount done. I would say the ACT Party has had a massively disproportionate influence on this government without needing to make policies bottom lines.
Why do you think that National will go along with it this time round?
Well, I look at the speech recently given by the Attorney-General, who's a National MP. A lot of this is similar to that. The National Party has been happy to legislate over the Marine and Coastal Area Act because they recognise the problem. So I can't speak for them, but I think they recognise this issue and they will be willing to engage to form a new government to give people one law for all and one future together.
Is this eroding aspects of the treaty within New Zealand law?
I don't see why. This is about the courts knowing their proper place and Parliament having its proper place. The treaty, that can be litigated and debated, but we have to at least know who makes the law, who interprets it.
Have you had a legal expert look over this?
We certainly have. A lot of the ideas here have come from quite a prominent jurist.
The Waitangi Tribunal ruled that your work earlier, clarifying treaty clauses, breached treaty principles. Is this going to be the same story, or is this? Why is this slightly different?
Look, the Waitangi Tribunals played an honourable role settling past grievances. Their judicial activism today is a very good example of the kind of thing we need to change.
Will you engage with Māori before you actually try and push these changes through?
I don't know, Karen. Are we engaging with Māori? I think that's your answer.
In terms of tikanga and how courts can use it, how do you envisage Parliament outlining that as well?
Sorry, just say that again.
In terms of like how the courts can use tikanga, like you're saying, how do you envisage Parliament?
There's a long settled tradition of tikanga being relevant to cases where the people involved in the case actually use tikanga. For example, if you had a dispute between two iwi, say over a piece of land or a fishing ground, then obviously tikanga would be relevant to their historic relations and the rights and wrongs of who's done what in the past. So that's always been a legitimate place for tikanga in the law. But what you've seen from the courts, particularly in the Peter Ellis case, is trying to extend that legal concept into areas where it was completely irrelevant to the case. And that's wrong for two reasons. First of all, they weren't actually building on facts relevant to the case before them. And second of all, they were actively trying to spread, frankly, a political ideology through judicial decisions. We don't want the courts to do that. We want courts that will soberly interpret the laws made by Parliament and apply them to each case with the best of intentions. Not a court that sees an opportunity in a case coming before them to try and change the constitutional direction of New Zealand totally outside their remit.
But how are you going to enforce that?
Well, it'll come through in the changes to the Senior Courts Act and the Legislation Act. Those will make it clear that Parliament, and bear in mind, the Supreme Court was created by Parliament, so everything that they do ultimately follows parliamentary law. It's just that, frankly, they've forgotten where they came from and become a little bit politically ambitious for anyone's liking who takes democracy and the rule of law seriously. So we will make changes in those two pieces of legislation that make it clear that tikanga, in its traditional formulation, where the people and the case are relevant, go for gold. But don't try and apply it to places where it has no relevance for political purposes.
What evidence do you have that Kiwis actually want these changes?
It's the sense that people bring up frequently that something's not quite right. It doesn't feel like the country's going in the direction that they voted for, and it's often people who they didn't elect and may not have heard of, with all due respect to those justices, who are making the decisions. You take the Marine and Coastal Area Act, enormous frustration with that. You take the people who lost their rights over greyhounds, or those people who had their firearms confiscated, enormously frustrated that there's actually no recourse to say, hey, what about our property rights? So there's lots of people in different circumstances. The people who look at 3 strikes and say, I thought my attacker would be going down for the max. That's what Parliament said. That's what I voted for. It didn't happen. So there are no shortage of instances where these cases have seriously undermined people's trust, both in the legal system and the democratic system. When they mix up, people can't tell what's what and who's to trust.
You say there's a sense. Is that enough to put something like this forward? It's pretty huge changes.
Well, there'll always be people who think the only thing that's worth listening to is an academic journal article. Frankly, My job as a politician is to knock on the doors, ask the questions, listen to the people, meet them in my office, have the street corner meetings and the conversations, hear people's concerns and aspirations, and then put those into a program of change so the country better reflects the hopes and concerns of the taxpayers who actually pay the bill. And I think people, I've had this a number of times, people say, oh, you're just listening to people. Yeah, I am. I'm listening to people who have to follow the law, who have to pay the taxes, they vote, and they want results.
How would you convince potential coalition partners to support this?
Well, I think they already have considerable frustration. You saw it in Chris Bishop's speech the other day. You see it in the Marine and Coastal Area Act. You see it in the government putting back 3 strikes. So they already share the concerns that we have. What the ACT Party's brought to the table is a clear way to address concerns that all 3 coalition partners share to differing extents.
So you've already referred to one esteemed Māori who you will be consulting, but don't you accept that a majority of Māori will not be happy with what you're putting forward?
No, I don't, and I think we've got to start talking about evidence. First of all, Māori don't think with one voice, so there's never going to be a Māori view. To say all people of one race think alike, that's quite an icky way to think. Second of all, I think it's critical that everybody has a say on the future of our country, no matter when your ancestors got here. So will Māori be consulted? Absolutely. Will Māori be consulted because they're Māori or because they're special? No. We're all going to be consulted as human beings, starting with an election and then with a lawmaking process. That's called democracy, and it's the greatest system of government ever invented.
But there was a lot of anger to Treaty Principles 1.0. How come you don't expect there to be a lot of anger for Treaty Principles 2.0?
Well, first of all, other people's anger is not my responsibility. But as I've answered in the earlier question, the simple fact is that a lot of the frustration and the anger that came out of the Treaty Principles Bill was the misunderstanding that it would somehow change Te Tiriti itself. Now, that was wrong, and there's a huge amount of misinformation out there. Nonetheless, some people went down that pathway. Other than clarifying the language used when Parliament mentions the treaty, which I think everyone should agree needs to be done, this doesn't actually change the treaty itself. So the main driver for that angst is not here, but quite frankly, other people's reactions and misinformation should not become a veto on reasoned debate in our country.
Just a question about the Legislation Act, and I've been sent this by a journalist who's also a lawyer, so just bear with me. Basically, they're saying that judges can interpret sort of new meanings, say, for the word document, for example, can include DMs or group chats and things like that. So judges always interpret that moving forward. Are you expecting there to be sort of every time there's a slight change in the word documents for Parliament to have to look at that and to change the law every time?
So people have this idea of a thick version of the rule of law and a thin version of the rule of law. And under the first one, you can basically choose whatever you want to be the meaning. Under the other one, you've just got to go with the letters. It's always going to be a spectrum. We're not saying that judges won't be able to decide that a text message is a document. What we are saying is that they have to start having regard for what Parliament meant, not what they think is important, because too often they have said, look, that very reasonable ability to interpret Parliament's intent for a specific case has been expanded to carte blanche to have totally different meanings derived from Parliament's intentions.
But it sounds like you just don't trust judges as much as anybody has in the past.
Well, frankly, the way that judges have behaved in the last 5 or 10 years has been quite different from any other time in our history. If Parliament says the Marine and Coastal Area Act meant full and uninterrupted occupation for 180 years, you wouldn't expect the courts to say, oh, no, if a few other people used it for a period of time and you weren't there the whole time, that's all okay because tikanga. That is why I think a lot of people have had their trust eroded. We're here to restore this trust, and ultimately we want our system of government to work. We want the courts to be trusted, we want the Parliament to be trusted, but when they play in each other's lanes, you can lose trust in both.
On the Constitution Act, everybody accepts surely that everyone is equal before the law, and that's sort of a principle that's already there. Why does that need to be enshrined?
Well, I mean, in theory, everyone's equal before the law, but tell that to people who've found that there is a Maori quota for council procurement. Tell that to people who have missed out on going to medical school because there was a different quota from people of a different background. Tell that to people who have to basically pay for cultural impact assessments in order to do a development such as the ports of Tauranga. The facts are that we have been treating people differently based on their background for far too long. Once upon a time, it was unthinkable. You know, this is a country where Kate Shepherd said that all that divides, whether it be by race, class, creed or sex, is inhuman and must be overcome. This is a country that in 1847 said people should have religious freedom at school. This is a country where people got out and protested against apartheid, even if it meant missing the All Blacks. And wasn't that a great game last night? And yet somehow we've now accepted that you can have two people showing up to a doctor and one gets a prescription and the other doesn't because of when their ancestors came to this country. I'm sorry, that is totally wrong, and I'm pleased, by the way, that Pharmac has fixed that last one in respect of diabetes medicines, but there's a lot more to do.
I mean, but equality before the law, I mean, does that not need to be just left there as a principle rather than you saying this?
Well, I think Parliament needs to start showing some leadership and asserting a few things, frankly. For too long, we have, as you quite reasonably begin, say, look, surely this stuff is so obvious it doesn't need to be said. Unfortunately, more and more New Zealanders are frustrated with policy which shows us it does need to be said. Right. Now, just in case you don't ask me, look, I called him cynical Chris Hipkins, and today's so-called fiscal plan is a pamphlet masquerading as serious policy. This is totally focus group driven, and the numbers don't stack up. You've got 33% of GDP being spent by Labor. That's 3% more than the government is on track to spend. They want to spend $15 billion more with a capital gains tax they admit will only raise $1.3 billion more. Where are they going to get the other $13, $14 billion? They don't know, but I can tell you it will be from their friends in Labor, TOP and the Greens and Te Pāti Māori together threatening 9 new taxes. Or maybe their plan to have a dual mandate for the Reserve Bank means they'll just print the money again, as they did last time. You cannot trust Chris Hipkins, just as so many parents sadly found out you couldn't trust him to be reliable on the vaccine safety during COVID. You can imagine him saying that his numbers will add up, but they absolutely won't. This is back to the future with Ardern-era policies, but actually threatening to spend $15 billion more that they can't stack up. Just wanted to say that. It made me feel good. All right. Well, look, I really appreciate you guys coming along. I hope you have a great day. Cheers.